If your child's behavior issues have resulted in a series of suspensions totaling more than 10 days in a school year and constitutes a pattern, your child is at serious risk of being placed on the path of the school to prison pipeline. The school to prison pipeline is a process through which students are pushed out of schools and into prisons. Today is my part 3 of my 3-part series, The School to Prison Pipeline. And today I'm going to be sharing with you 3 steps that you can take to protect your child from becoming a part of the horrific school to prison pipeline. Now, parents, please go back and listen to part 1 and part 2 of the school to prison pipeline, because in part 1, I give you all the foundational information you need to understand what the school to prison pipeline is. And in part 2, I talk to you about the proactive steps that you can take as a parent to make sure your child does not get placed on the school to prison pipeline. Today, I'm going to be sharing with you when your child is being suspended and has behavior problems, behavior incidents start occurring at the school that starts causing suspensions and then could lead to expulsion. So I'm going to be giving you 3 steps today on what that looks like, what those steps look like that will lead to expulsion, and then your child will actually be on the school to prison pipeline once your child is expelled from school. So the education code says, in the case of a child whose behavior impedes the child's learning of themselves or others, the IEP team must consider the use of positive behavior interventions and supports and other strategies to address that behavior. So the 3 steps that I'm going to give you today are step number 1 is the BEAR. That means the Behavior Emergency Report is a BEAR, B-E-R. So the BEAR means what that will happen is when the behavior that risks harm of self or others and emergency intervention was used, meaning there was laying on of hands on a student. Now, when a teacher or aide or any staff personnel lays hands on a student, they have to be credentialed and highly trained to know how to lay hands on your child. If they are not, they are breaking the law and they are not allowed to lay hands on a kid. They have to have specific credentials and specific trainings in order to lay hand on a student, and it must only happen when a child is at risk of harming themselves or harming others. So let me just give you some information about emergency interventions and restraints and seclusion instead of doing other positive behavior interventions. Emergency interventions may only be used to control unpredictable, spontaneous behavior that poses clear and present danger of serious physical harm to the individual with exceptional needs or others, and that cannot be immediately prevented by response less restrictive than temporary application of a technique used to contain the behavior. So meaning they cannot use restraints or laying on of hands unless that child is going to actually be at risk of harming themselves or others. Further, emergency interventions shall not be used as a substitute for the systematic behavioral intervention plan that is designed to change, replace, modify, or eliminate a targeted behavior. So if there's a behavior intervention plan in place for your child, that behavior intervention plan and FBA must first be implemented before any laying on of hands takes place. And if those strategies aren't going to work, that's the only time they can actually use physical restraints or lay on of hands. Now, if that starts happening to your kiddo and they start and they lay hands on your child, a BEAR, B-E-R, Behavior Emergency Report, must be written. And once that happens, that's a huge red flag. And that means your child's getting close to being put on the path of the school to prison pipeline, going to start being suspended, and then possibly expelled. It's opening the door to the school to prison pipeline. So if a bear is written regarding a student on an IEP who does not have a behavior intervention plan this is what the school district must do. Within 2 days, the school site administrator is responsible to schedule an IEP to review the emergency report, to determine the necessity of an FBA, a functional behavior assessment, and to determine the necessity for an interim plan. So if a bear happens within 2 days, the school site administrator must call an IEP meeting. They must look at what happened in the bear, what was the incident, what was the behavior that caused this incident, and they must look at if a functional behavior assessment was not conducted, they must conduct one. And if it was conducted, they must look at the BIP, the behavior intervention plan, and they must consider amending it. So that's a bear report. Disciplinary action is taken depending on the age of the student. So it depends if a bear report happens. If a child's older, then they're going to suspend that child, no question. If a child's little and in grade school, they're going to call the IEP meeting, they're going to talk to the parents, they're going to look at conduct an FBA or look at the FBA and look at the BIP, and they're going to possibly amend that. After the incident, they're probably going to call the parent, and they're going to have the parent take the child home for the rest of that day. And most likely a suspension may not happen. It depends on how many times a bear has been written. If it's been many times, they might suspend the child. If it's the first time, they probably wouldn't. So it depends on the age of the child, whether that child's going to get detention, suspension, or expulsion. If it's been close to 10 days of suspension, that child could be expelled. So if a bear is written, the district must do those things without delay, within 2 days, and that's what must take place. Now, the problem is that many times this does not happen. I had a client where this kid was getting bears once a week, twice a week. They weren't calling an IEP meeting, and they weren't following the law at all. So this is the importance, parents, of you knowing what your rights are and you knowing what the district's responsibilities, obligations, and duty is when behavior incidents occur, so that your child doesn't continue to have behavior incidents. They are responsible to teach your child how to replace those negative behaviors with positive behaviors. And by not calling an IEP meeting, by not having an FBA done and a behavior intervention plan written, your child is going to continue with the maladaptive and disruptive behavior and possible behavior that might place them at harm if it's self-injurious, or place someone else, another student, at risk of harm. And the school district is not keeping up with their obligations to teach your child how to replace those negative behaviors, so that this does not become a problem for your child. Your child's at risk of, if they're in grade school, of growing up to continue to be suspended and then possibly expelled from school. So that's the first step. Number 2 is the manifestation determination. So if your child has a series of suspensions totaling more than 10 days in a school year, and it constitutes a pattern of behavior, so the pattern looks similar, the behaviors look similar in those suspensions, then the IEP team must determine if the conduct was caused by or had a substantial relationship to either 2 things: the child's disability, so that the conduct of the behavior was caused by the child's disability, or was caused by the district's failure to implement the IEP. They must look at those 2 things. Those are the 2 questions when they call a manifestation determination meeting. So again, if your child has a series of suspensions, and believe me, it doesn't have to be 10 days. It can be that I've seen them call a manifestation determination meeting after 6 days of suspension only. And I'm like, I asked them, why are you guys calling a manifestation determination after only 6 days of suspension? It's not even close to 10 yet. Well, we just want to look at the behavior, because this behavior has continued to be a problem, and they are continuing to be suspended. So we want to call a manifestation determination meeting. Okay. But they can call one at any time if there's a series of suspensions that constitutes a pattern. They can call a manifestation determination, and that's a serious informal hearing, an IEP meeting. They call it an IEP meeting, but it's really an informal hearing where they look at those two questions. Was it a manifestation of the child's disability? And two, did the IEP team implement the IEP? Now, what does that mean, implement the IEP? It means, did they implement the behavior goals in the IEP? Did they implement the behavior intervention plan in the IEP? Did they consider the functional behavior assessment and all the information in that? And did they, in good faith and with fidelity, implement the IEP? Those are the two questions. So the manifestation determination meeting requires the attendance of the parent and other relevant members of the IEP team. Suspension rules apply. The suspension rules still apply to children in special education, just as they apply to non-disabled students. However, there are procedural safeguards that protect your child on an IEP. And these are the things I'm telling you today. These are the procedural safeguards. So proactive measures to avoid suspension, go back and listen to part 1 and part 2, parents. Those are the proactive measures you can take to avoid suspension of your child and avoid having them be placed in the school to prison pipeline. So what would constitute a manifestation determination informal hearing? Suspensions for more than 10 consecutive school days or 10 cumulative days. So it can be, the child can be suspended for 10 days in a row. And that is when there is a student conduct violation of student code of conduct was broken. They can be suspended for 10 cumulative days. I'm going to review with you what is a violation of student code of conduct. Okay. They can be suspended for 10 consecutive days or 10 cumulative days for the same or similar offenses, and that constitutes a pattern of behavior, and they decide whether the child is going to be expelled or not. That's a manifestation determination informal hearing. So what is the district mandated to do in a manifestation determination? They are mandated to determine if the conduct in question was caused by or had a direct relationship to the child's disability, and if the conduct in question was a direct result of the school district's failure to implement the IEP. So those are the two questions that must be answered in a manifestation determination meeting. Now, if a student violates the code of conduct of all schools, that code of conduct means that, and it's called the special circumstances, it means school personnel may remove a student into an interim alternative educational setting, meaning they're going to be taken out of their public school and placed in a non-public school for kids that violated the code of conduct for students. So they're going to remove them and place them in an interim alternative educational setting for not more than 45 days. They can only place them there for 45 days without regard to whether the behavior was a manifestation of the child's disability. So if they break the code of conduct, even if that behavior was a manifestation of your child's disability, they can still take them out and expel them into another non-public school for 45 days. In cases only when a child carries or possesses a weapon to or on the school premises or to a school function. So carries a weapon anywhere at school premises or a school function. Number 2, knowingly possesses or uses illegal drugs or sells or solicits the sale of a controlled substances while at school or school premises or at a school function. Number 3, has inflicted serious bodily injury upon another person while at school, on school premises, or at a school function. So the code of conduct no procedural safeguards for an IEP. Boom, your child's expelled for 45 days, removed to a non-public school, and then, but then they get to come back if it was a manifestation of your child's disability for breaking the code of conduct. Okay. So, so when that does happen, and if the IEP team makes the determination that the child's behavior was a manifestation of their disability, the parent, the relative members of the IEP team make the determination that the conduct was a manifestation. They must, these are the things they must do. They must conduct a functional behavior assessment, an FBA. If one has not already been conducted, they must conduct an FBA. And an FBA must be conducted when school authorities seek to change the placement of a child with a disabilities because of a violation of the code of conduct, and the IEP team determines that the conduct was a manifestation of the child's disability, and the local educational agency had not conducted an FBA prior to such determination before the behavior that resulted in the change of placement. So they must develop an FBA. Number two, in the situation where a behavior intervention plan has been developed, they must review the behavior intervention plan and modify it if necessary to address that behavior that caused the violation of this code of conduct violation. And a behavior intervention plan must be implemented when school authorities seek to change the placement of a child with a disability because of a violation of the code of student conduct, and the IEP team determines that the conduct was a manifestation of the child's disability, and the local educational agency has not conducted an FBA prior to such determination before the behavior resulted in the change of placement. So if they hadn't conducted an FBA, they must develop a behavior intervention plan immediately. They can't say, well, we're going to do an FBA first and then we're going to develop a BIP. Nope, they have to immediately develop a BIP, and then they need to start an FBA if one had not been done previously. Okay? And then they must return the child to the placement from which the child was removed, unless the parent and the local ed agency agrees to a change of placement. So sometimes the parents want to move their kid out of public school because they don't want their child going back to the same school site that they either were, had drugs or had a weapon or got in a fight and really harmed someone else or got harmed. Okay, so those are the rules for when there is a violation of the code of conduct. And so let's talk about what happens when a child is found to have the behavior not a manifestation of their disability, which really, parents, I'll tell you, I've never had a manifestation determination meeting where the behavior was not a manifestation of the child's disability. Come on, kids on IEPs, their behavior is a manifestation of their disability, and the school districts will try and tell you that it's not, but it is. So, and this is what happens when parents don't know what a manifestation determination is, and they just go to the informal hearing, the manifestation determination IEP meeting, and the district goes, oh, we don't believe it was a manifestation. Nope. And yes, we implemented the IEP. Boom, your kid's expelled. Bye-bye now. And that's what they do. Parents have no idea that they have rights, and then they could say, no, I absolutely disagree with that. It was this behavior that occurred that caused 6, 7, 8, 9, 10 days of suspension. Every single one of the suspensions was a manifestation of my child's disability, and no, you cannot expel my child from school. And in fact, you have to do a functional behavior assessment and develop a behavior intervention plan, and you have to write 3 behavior goals, and you have to give me a ABA behavior aid because you aren't doing what you're supposed to do, school district, and you're obligated to do under the Individuals with Disabilities Education Act. So parents, know your rights. Know how to protect your child on an IEP, and know what to do. Please listen to part 1, 2, and 3 of School to Prison Pipeline and know how to hold your local school district accountable to providing your child with the behavior interventions and supports they require and that they deserve and that are necessary for your child to be able to learn and have good behavior in school. So parents, please like and share this video, and so other parents can get this information that are in need today. In the circumstances we're having now, so many kids are self-harming, are depressed, are having a really hard time with behavior, and this is important information that parents need to know. And I'll see you next Monday morning for my next Facebook Live. I'm Valerie Abrahamian, the IEP Navigator, and I support, coach, and assist parents to get the IEP their child needs to thrive, both in school and in life after high school. Take care, everyone, and God bless.